having downstream liabilities and responsibilities when certain things happen is very important. And talking about how to have insurance protect you and how the insurance mechanics work is something that many of you may not be aware of. And I can tell you from my experiences, we should listen to what Uri has to say, because if you do it correctly, it will save your company, it will save your cost, and it'll put you in a good position. And if you write the kind of provisions as Bruce was talking about, which we'll get some more sample provisions that will circulate after the program, probably early next week, I'll be talking to you a little bit more about how we're going to do that after the program too. But Uri, let's get into your part of the program and talk about how subcontractors and GCs need to worry about insurance risks and how they manage that problem.
Thanks, Hal. Just by way of background, I spent many years working in insurance, first for a big law firm in New York called Skadden Arps, and then I worked in-house for an insurance company in New York. After that, I was general counsel for a developer, so I've actually seen some of these issues that I'm going to be talking about arise both on the subcontractor side, the owner side, as well as the general side. It's probably when I say it, I mean insurance, and the interplay between insurance and indemnification is probably the most overlooked issue when it comes to these contracts. I think most of you are generally familiar with the concept of indemnification. You know that it's in there, you know that it's a fact of life. You know that there's some correlation between indemnification and insurance because the contract talks about those things. But in reality, they are essentially inseparable or inseparably intertwined. And you have to analyze them together. If you don't, it can be sort of a bigger nightmare for you and potentially a life ender for you, worse than any of these other killer provisions that Bruce talked about earlier. The issue typically arises when an owner sues a general, defect case or what have you, and the general in turn brings in the sub. Included in those claims is a claim for indemnification. And the indemnification claim is typically tied to a contractual provision that says that the subcontractor is obligated to indemnify the contractor. And for what? We'll talk about in a minute, because there are generally three different types of indemnification provisions. And then the sub says, great, well, here's a certificate of insurance that I provided early on. So wonderful. The contractor must have coverage under my policy as an additional insured because I provided the contractor with a certificate of insurance. Wrong. A certificate of insurance is not what does it, and we'll talk about that in a minute. So whenever I represent subs, this is the thing that I lose sleep over more than anything else. Are the indemnification provisions properly worded, and did we properly secure that contractually required additional insured status for the contractor? And then has the claim properly been tendered, which is submitted to the insurer, such that the insurer is going to pick up the defense of the claim? And when I say defense, it's as important, but in many ways it's even more important than the actual indemnification, because the defense costs, as many of you know, in these cases are potentially so high and so expensive that in and of themselves, they can be killers. So let's just talk briefly, backing all the way up, about what an indemnity agreement is. So an indemnity agreement in a construction contract is a promise by which one party, for purposes of our discussion, the sub, agrees to defend, indemnify, and hold harmless the other party, which, again, for purposes of our discussion, is the contractor, for acts or omissions related to the project. There are generally three, or historically, I should say, and I'll explain why in a moment, three forms of indemnification agreements. The first is the broad form type 1, which includes the sole negligence of the contractor. They sometimes try to slide them in, but as we'll discuss in a moment, many, or actually most states, have now enacted these anti-indemnity statutes, which severely restrict the enforceability of those types of provisions. And then the second type, type 2, the moderate form, which includes all negligence except for the sole negligence of the contractor, which is still pretty bad. And Bruce alluded to that earlier, his example of the 99-1 allocation of fault. And then type 3 is the narrow form, which includes only the negligence of the sub. And most states have adopted statutes that determine which of these types of indemnity agreements are enforceable. And we try to keep up with this by way of survey, national survey. And on the last survey we conducted, the only states that do not have a statute that limits the enforceability of indemnification provisions in construction contracts, or have a provision that's very limited, are Alabama, Maine, Nevada, North Dakota, Pennsylvania, Vermont, Wisconsin, and Wyoming. So that's roughly 8 states. And even in those 8, many of the courts, again, statute versus court decision, many of the courts have narrowly interpreted provisions that provide, or that provide for indemnity of a contractor for its own negligence. The rest of the states have either broad or moderate prohibitions on these types of indemnity agreements. So it's important for this analysis to be done on a state-by-state basis. So I know that some of you sort of are licensed in various states, especially states that consist of a metropolitan area that covers more than one state, and that can actually vary. So it's important that when you're entering into these agreements that you study the indemnification language that's being proposed. Do not take it as a given. It can, on its face, depending on which state's law should apply, which is sort of beyond the scope of this discussion, can be invalid. That in turn, if you don't deal with it on the front end, can create issues relative to additional insured status. That is an obligation that also exists under the contract, where you as the sub are required to provide additional insured status for the contractor under your insurance coverage. If the provision that is in the contract is void or unenforceable, and then you attempt to mistakenly include that type of indemnification under what's called the contractual liability coverage under your insurance, that also creates confusion and can become problematic. So it's important to deal with it on the front end. So just to talk briefly about sort of the interplay, you might say, well, what is exactly the correlation between insurance and indemnification? Well, generally, under an insurance contract, an insurer will not provide coverage for liability that you assume via contract. So you can't get insurance for breaching a contract, generally. One of the key exceptions under your contractual or comprehensive general liability policy is called contractual liability coverage as it pertains to indemnification. So if you contractually agree to indemnify a third party, your insurer is obligated to provide coverage for claims that arise pursuant to that indemnification obligation. If you did not contractually agree to indemnify, in most cases, or I don't want to say most, but in many cases, then the insurer, your insurer, will take the position that, excuse me, there's no contractual liability here that is an exception to the general rule that says no coverage. There's no contract that requires this indemnification. So by including this indemnification provision in the contract, that triggers the insurance coverage that applies to respond to those indemnification claims that the contractor makes against you as the sub. So I think you're starting to see the clear interplay between the two. So let's talk briefly about what I alluded to earlier, this distinction between additional insured status that comes from what's called an additional insured endorsement versus what many of you may be familiar with, which is called a certificate of insurance. Certificate of insurance, some of you may see that it says Accord at the top, ACORD, okay? That is a certificate that identifies the certificate holder, but it is not the same as a legally binding act or document that gives the additional insured status under your policy. And the certificates of insurance are often issued by brokers, and they're good in the sense that they can be done quickly. Oftentimes, this is a fire drill, right? You're checking off boxes. Where's the proof that I've been added as an additional insured? Here's the certificate of insurance. I got it from my broker. And it's not enough. It's not enough. It's not enough because if you didn't do it right, the contractor could have a claim against you as the sub for breach of contract. You were contractually obligated to add the additional insured onto your policy. If there was a breakdown in some way and you didn't do it, it's a breach of contract, number one. Worse, the contractor sues, files a claim against you, the sub, and because of something that happened, you didn't properly have this endorsement issued that gives the additional insured that status under your policy. Now what? It doesn't make the indemnification claim go away. It's still there. But now you're on the hook for it. And you potentially now have no coverage for what can be a life-ending claim that for indemnification that the contractor makes against you, the sub. So it's clear that you have to be careful, distinguish between certificates of insurance and additional insured endorsements that will clearly indicate that the additional insured, that the contractor has been named as an additional insured under your policy.
Uri, 1 second. There's a question from Melissa Williamson. She wants to know if we as a sub have the certificate of insurance sent to the GC and it does not have the proper coverage outlined, who's responsible for the proper coverage not being in the insurance policy?
That's a great question. So unfortunately, the buck stops with you because it was your contractual response, you as the sub, it was your contractual responsibility. Now, you may have potential claims against your broker who screwed up in some way and didn't properly do that which you asked the broker to do. But who wants to deal with that? You are now then on the hook, you are now facing the potential devastating consequences of having to defend these claims yourself. And now you have to potentially go after the broker for the broker's errors and omissions and not having properly had this additional insured endorsement issued. You don't want that. So it's better for you to do your due diligence, whether it's a paper or a physical binder, have a file. You got to have that. You got to put it as one of the important things on your checklist. You've just got to have it. And one of the other things that should be done periodically is you should verify your coverage. So one of the things that happens sometimes in the event of claims is something called the erosion of limits. Erosion of limits means, for example, you have $1 million in primary coverage and $2 million in umbrella coverage. And you might think, you know what, that's enough to protect me in my own business. And it could very well be. And when I say in your own business, I mean direct claims that are made by third parties against you. You may think that sounds like more than enough coverage. It may be, again, but it may not be as it pertains to indemnification claims that the contractor can make against you as the sub. Think about it. Big construction defect claim. You're a stud or drywall a sub. Bunch of construction defect claims arise out of that trade, out of your work. And the contractor says, out of the total claim, we believe that 5 million of it, you sub are on the hook for it. And then you then realize that maybe the insurance coverage limits that you had in place that you thought would be enough to respond to direct claims against you are not enough to respond to indemnification claims that are essentially indirect claims that the contractor makes against you as the sub. So it's important to periodically check those limits. There's also an argument that to be made by the contractor that if you took on this responsibility to provide additional insured status to the contractor under your policy, and your limits were eroded, that you breached by virtue of that alone. So it's important to review. Do not count on your broker to perform this review for you. The broker doesn't necessarily know all of the stuff going on in your world, all of the claims that are potentially contingent claims. I don't think it's really reasonable for you to assume that your broker should know about all that. They don't know the intricate details about all of your jobs, the potential risk factors associated with those jobs, whether any issues arose during the course of those jobs that have not yet materialized into claims but might in the future. You need to have a handle on that. So I was going to talk more about some of the other what are called proprietary endorsements that insurers try to slide in order to restrict coverage. And some of these are very significant because, again, it could be that you are on the hook and you're required to provide this additional insured coverage to the general. But by virtue of what are called these proprietary endorsements, your insurer has severely limited the coverage that is going to be available. And I'll just give you a few, but there are many, because obviously, think about it, the insurance company's job is to collect your premiums, of course, but then pay out as little as possible. That's just the reality. So they're going to do that in ways that may, on the surface, seem reasonable, but in reality are not, because they don't provide you with the level of coverage that you need with respect to the obligations that you've contractually incurred with respect to the contract. And that's problematic. So some of the endorsements restrict coverage by virtue of speaking to time limits, limits of liability applicable to the additional insured that are restricted by the amount of limits required in the contract. So you're required to maintain a minimum of X coverage, okay? But that conflicts potentially with the indemnification obligation. The insurer might take the position by virtue of this endorsement that its liability is limited because of the fact that you agreed to only maintain X dollars in limits in the contract. Other examples are notice of occurrence, where the insurer will only cover claims where notice has been given as soon as practical or practicable. What about claims where they don't raise their head for months or even years afterward? That could potentially be another means of the carrier declining coverage. So you need to look at those. And you need to get a handle on claims, even if they have not formally been made against you, because that can have a potentially make or break effect on the availability of coverage. And then the other one, this term that you've heard us use here today is the tender. The tender is the process by which a claim is submitted by the insured, whether it be you or the additional insured, to the carrier. Tender has to be done right. It has to be done timely. There are many, many issues surrounding tender. Oftentimes, you need to be careful about which policy you're tendering under. So you may or may not want to tender under all of your policies when you have different types of policies, because there might be different types of exclusions. You might be in a better position under one policy over another, because the likelihood of the carrier having to take on the defense obligation, which is much broader than the ultimate coverage obligation, that could be a make or break for you. So if one of your policies has potentially broader defense coverage, you may want to tender under that policy rather than the other policy initially. Other limitations speak to negligence versus your work. So, you know, the most insurers will only provide coverage to your negligence other than coverage arising out of your work. So whatever work it is that you performed that was faulty, the carrier is not going to want to pick up the tab for that. But if your work caused other damage on the project, that is outside of the confines of the limitation that applies to your work, and that they will provide coverage for. So those nuances in terms of how to describe exactly what's going on and what's at the heart of the claim could make or break the availability of insurance. I think I'm out of time, but the takeaway, it's important. Don't gloss over it. Understand the interplay between indemnification and insurance. Study your insurance. Be careful about relying too heavily on your brokers. And whenever issues arise, think insurance. It should be the first thing that pops into your head, think insurance. If there doesn't end up being coverage, there doesn't end up being coverage. But if you don't think of insurance first, you're potentially missing out on perhaps your greatest way of surviving a disastrous or catastrophic claim by a contract. Thank you.
Great job, Uri. What happens that I've seen a lot is general counsel to many companies around the United States that we represent together, that you get a letter from the general contractor to the subcontractor, and they say to you, you obligated yourself to protect and defend me against certain items, and if you don't, like a loss or defects or property damage to the building or to other people's work, then you're going to go ahead and be responsible to defend me. I'm asking you to tender this lawsuit or this claim to your insurance carrier. And there's a bunch of different insurance policies, kind of what you just said, with certain choices. Sometimes you got to think about, what insurance do I have? So we have, maybe you can like summarize, what is the insurance that a subcontractor or a GC would typically have that they would then tender the policy to?
So thanks, Hal. So the one that I spent the most time discussing today was what is commonly referred to by the acronym of a CGL policy. So that is either a commercial general liability policy if you're on the insurance side, and if you're on the policyholder side, it's a comprehensive general liability policy. You might say, well, why the difference in the vernacular? Well, because of course, as the policyholder, you want that coverage to be comprehensive. As the insurer, you don't want it to be so comprehensive. So that's what we spent most time here discussing, and that is generally what's called an occurrence-based policy. It's triggered by an occurrence, which is, an hour discussion of itself. But there's also a errors and omissions type policy that might apply. Sometimes a sub's work goes into areas that are more design oriented, for example. So an example might be a stud and drywall sub that also does some exterior cladding work on a building where, the issue arises as to whether their work complied with shop drawings or something like that, or a mock-up. And so that can potentially trigger a different type of policy. So it needs to be studied when the claim comes in.
Well, I think the point that you raised, which is really good, is that you need to inventory your policies, because you're going to forget them in the heat of the battle. Because with today's overload of information, your mind isn't always working, as sharp as it should be all the time, unless you're very lucky and you have a good team around you and you yourself are familiar with this. But it takes years and years and years to kind of get the instinct of what you're talking about. And I'm really glad you brought this subject up, and you did a really great job summarizing it. So like you mentioned, like policies that he wrote, well, those design policies, or the, I think they're called professional, what do they call, professional design, or something like that. Mainly they would be, as you said, for somebody that's signing a contract and they do a design build. Okay, then they take that responsibility. Then you've got the word in contracts, design assist versus design build. How far does it go? I was talking to a few of my construction manufacturer clients this week in California. I think I mentioned this case to you, this California council. I mean, your state has California licenses for contractors. My client was an out-of-state manufacturer of window products, and the subcontractor claimed that we were not going to get paid. We're having a battle trying to get paid on the job. We've liened it, we're litigating it. And he asked in the litigation, he said, hey, I'm suing you because I paid you money, and you were a design build party, therefore you're a contractor, you're not just a manufacturer, and I want to take all the money I paid you, since you didn't have a license, and gorge it out of your pocket and give it back. Now, naturally, as counsel, who was at the beginning of the job, which we were, and we sent out the notices and we filed the liens, we weren't even thinking of this possibility could happen. You got to give these guys credit as a subcontractor to having such imagination. But when we pointed out the terms and conditions to the judge said, even though you're providing shop drawings, you're really not the engineer of record. You're really not the designer. The fact that you did what are called structural calculations in a window frame to make sure that the structure of your product will, in conjunction with the building, be in accordance with code compliance. So it's not falling out in heavy winds and rains and things like that. That doesn't make you a contractor. That makes you a manufacturer that's doing your job and making sure you're engineering your product correctly, not the building. And the judge threw the claim that we were a construction contractor and therefore needed a license, thank God, out the window. Okay, that was there. And the best part about the case was then the judge ruled that he decided this because he used the words design assist in the standard terms and conditions, and that we weren't responsible for, like in Gene's client's case, consequential damages, late deliveries, the terms of sale. So as a lawyer who was always writing this, it was nice to be able to tell the audience that we now have a set of terms that a judge has adopted, and he's already ruling in our favor on the license. I'm guessing, but we don't know, we'll find out, that he'll take those same terms of sale and put that for the benefit of our client. So our trial lawyer actually worked with us, and we strategically were pissed that he would dare claim we were a contractor and steal our money back. But then we said, all right, we're probably going to win this, but let's get our terms of sale adopted here too and convince the judge otherwise. So it kind of backfired on that subcontractor who, it's hard for me to like express myself so professionally, who tried to take my construction manufacturers, products that he never paid for, and try to take the little money they did pay us back. And in California, that could happen. You must be aware of that as a California counsel, if you don't have a license.
Yeah, so California is one of the states that is probably most draconian on that issue. So it's no surprise that they would try to trigger that to gain an unfair litigation outcome, frankly. But those types of provisions exist in other states as well, obviously. So very important when you're a even a third tier provider providing work on a project where you're crossing state lines, thinking, well, I'm not really doing work on the project. I'm sort of just a vendor, just providing a product as opposed to a service. Those lines are often blurred.
Right. Yeah, and there's people that are on a legal network that specialize in representing these issues in contractor licenses, as you likely are doing too. So one of the things that I think is important, speaking of California, let me share my screen with the audience for 1 second if I can. Is a case, let's see, that came down called United Riggers versus Coast Iron Steel. And Uri was talking a little bit about this today. So what I liked about this case, it started in Los Angeles, and it ended up in the Supreme Court of California. And I really like the perception of the Supreme Court of California. I think the audience would be interested. The judges say, this is the reported case, so it's very interesting. This case is about construction, physical and statutory. Spurred by late payment problems in the construction industry, the legislature established payment deadlines and imposed penalties on owners who delay payments to their direct contractors, and penalties on direct contractors who delay paying their subcontractors. But these deadlines include an exception relevant to this, that direct contractors can withhold monies from subs in circumstances where a dispute has arisen. And what we must decide is whether this exception allows withholding when there is any dispute between the party, or only when there's a dispute directly relevant to the specific payment that would otherwise be due. So I'm going to be sending some information out to the audience today afterwards, and we'll be taking some of the slides and information from our panelists and circulating that in the next few days. I'll send a copy of this case. I'm not going to tell you how the Supreme Court ruled. I want you to read the case. It's very exciting. It's pretty short, and I think you'll enjoy it. And what is the Supreme Court of California going to say? Can somebody withhold all your money or just the amount of money that's in dispute? I think it's 150% of the amount. So we'll see exactly how the case is decided. So let's pretend we argued it today and we're waiting for the court to make a ruling, and you'll get the surprise of seeing how the ruling will come out. This has been a really great audience, great questions people ask, and I want everybody to know National Lien and Bond has one passion. We work together, 50 lawyers in 50 states, notice services all across the country. trade associations, credit groups, and people like you to do one thing. We all together want to get paid when we do our work. And I think that's something that's really great for you as suppliers and subs and GCs to do. And it's great for a GC to pay a sub, and it's good for a sub to pay a supplier, and everyone to get along, after, they shake out whatever the problems are. Recently, we've been pushing non-litigation, but problem solving. And I can say that so far in the month of September, we've been able to solve a bunch of cases where I called up two people today. One Gene and I are working on in Bowling Green, Kentucky. And I asked the general contractor's project manager, hi, I'm not here to file a suit. I'm here to solve a problem. And then he complimented Gene's lien. He acknowledged that the lien on funds was good, very strong. He realizes they have payment bond claims as a GC, and the subcontractor also has payment bond claims. So the GC, through indemnity, said, hey, will you negotiate with the subcontractor? I said, as I said, I'm here to talk and listen. Let him call up Gene or myself, and we'll solve it, or call our client and we'll talk. Then we had another case recently, actually, that coincidentally Uri and I are working on. We don't know what's going to happen with that one. And Uri's client's having a little problem. We're trying to help out a little bit, where they need the GC who's been paid 2 years ago to pay attention. Like, when are we getting paid? So we called up the public job, and after like going round and round with COVID, can't get a hold of somebody. Somebody called me back today and said, are you the attorney or the client? I said, I'm the attorney for the client, a subcontractor that built your facility, and 2 years was in construction late. You know that. Because who's your client? So I told him. He goes, well, I can't speak with you because I'm not a lawyer. You can speak to our lawyer, but better yet, let me have either the lawyer call you or have the general contractor call your client. I go, good. Why don't you do both? And let's see what happens. So now there was no dialogue. We'll keep our fingers crossed, okay, that we'll get something done, who knows? But in the meantime, I want to thank everybody for coming. I don't see any more questions and answers. So ladies and gentlemen, we enjoyed having you, and get paid on your work. Thank you.